you very much, Nasir. It's such a pleasure to be able to address this particular session of the PhD chamber. Before I start my brief remarks, let me welcome the honorable member of the CCI, if I can use the word, my sister, Sangeeta Verma. It's such a pleasure to have her. She always obliges us at a short notice to share her thoughts with us on competition law. And it's the first event we are having with the new secretary, with you, Nasir. And if I may also extend a great and warm welcome to you in this particular gathering. And of course, we have our very dynamic young co-chair in Vivek. So very nice to have you with us. In fact, you are the pioneer or the driving force behind our this thing, and so is Ravi. So very warm welcome to all the participants. I can see there are about 44 participants right now, but the number is growing up. So I'm very happy to extend to each one of you a very warm welcome. Friends, we are meeting on a very special day. Today is International Yoga Day. And many of us, and if I can say me too, we started off our day today with doing some yoga practice. Although we should be doing it every day, not just one day, but at least for clearing our conscience, if nothing else. Many of us, like me, did our yoga today. So greetings to you all. And it's a matter of great pride and satisfaction for us in India, the yoga enthusiasts, that globally over 33 crore people, more than 330 million people, practiced yoga today across the world, from west to east and south to north, all over, and India also, and we could see visuals. So it's a very special day today. Coming back to the importance of competition law for MSMEs, I'd like to share some of my thoughts with you. And competition law was not very well known to most of us when we started off with the competition law. Many of the people, many of their friends used to ask, what do you do? Do you conduct competitive examinations and so on? But we have come a long way. We started off Competition Commission in 2009. I was privileged to be the first chairman. And since 2009, 20th May to be precise, when we started off our enforcement. So we have come a long way, and we have gone into our teens, so 13-year-old, and we recently celebrated that first year of teens. And competition law is really very important for MSMEs. Like for a parent, it is the smaller child or the younger child who is the most dear. So although there is no special provision for MSMEs in the competition law, but MSMEs are very dear to Competition Commission, if I can say so. And Mrs. Sangeeta Verma would bear me out that during some of their judgments, also some of their orders, they have been giving a long rope to the MSMEs to the extent they can within the contours of the law. Why so? Well, MSMEs are the backbone of Indian economy, exports and employment. They number about 63 million, 6.3 crores, and they contribute second highest to the economy after agriculture, which is around 35 to 40%. And they contribute 50% of India's exports and employment to about 10 to 15 crore people. That is what is the estimate, because their exact numbers are not available. And 1/5 of which are women entrepreneurs. In fact, the number is going up if you look at the startups these days. India itself is like a continent. It has 28 states, several bigger than many European countries. If UP, for example, was a country, it would be the fifth biggest country in the world. MSMEs are the charter of the states in the federal setup, although the central government also supports them in a big way. They promote local entrepreneurship, traditional skills, textiles, for example, arts and crafts, and they are soon migrating to technology-based sectors or infusing technology in their enterprises in order to remain competitive and ahead of the curve. This sector is largely unorganized and vulnerable to the dynamic external business environment. On one hand, small size of the SMEs makes them vulnerable to empty competitive acts of the bigger enterprises, including what we call in the competition law abuse of dominant position. And on the other hand, cooperation agreement among SMEs assist them to compete with larger enterprises and at times in the process expose them to the rigors of the anti-competitive agreements. Competition law deals with anti-competitive agreements. At times, the trade associations, they provide the platform for this, and willy-nilly they become a party to it, and abuse of dominant position, among other things. The third big pillar, which is section 5 and 6, mergers and acquisitions, MSMEs are not generally affected by that because they are below the threshold limit, but theoretically, yes. If we look at the preamble of the Act, it focuses on the economic development of, I'm just mentioning the key pillars of the preamble of the Act, giving the focus, the objectives. Main objective is the economic development of the Act, and all the other pillars, they converge towards it. To prevent practices having adverse effect on competition, to promote and sustain competition in markets, to protect the interest of consumers, and to ensure freedom of trade carried on by other participants in markets in India. It has to be borne in mind that everybody is a consumer in the economic value chain, more so the MSMEs, and to safeguard the interest of consumers as is envisaged under the competition law benefits everyone, and the benefit of economic efficiency and lower prices and better products would then be available to everyone ultimately in the value chain. The CCI has accordingly treated MSMEs as a separate or a significant constituency, not exactly a separate constituency. I didn't want to use the word treated them with kid gloves. That is for the member of the CCI to say so, but they have been formulating its competition advocacy initiatives accordingly. As regards the competition enforcement actions against MSMEs, Section 27 of the Act gives the CCI quite a wide discretionary mandate. CCI has taken into account the ability of MSMEs to pay a fine while determining enforcement actions. The statutory mandate of the CCI requires it to consider various socio-economic aspects mentioned, elaborated in the section 19, subsection 4, subsection K of the Act when investigating competition breaches. And these include generally entry barriers, which include entry barriers such as regulatory barriers, financial risks, high capital cost of entry, marketing entry barriers, technical entry barriers, economies of scale, high cost of substitutable goods or services for the consumers. All these factors become relevant because the CCI wants as many MSMEs as possible and lowering the entry barriers because that expands competition, and higher competition, greater number of MSMEs is good for everyone, good for competition. The competition law of India is size and type neutral under section 2H of the Act. The competition law does not distinguish between different types of economic entities. In fact, even the government departments and PSUs are included under the competition law. So there is a level playing field for the large enterprises, for the small enterprises, for the PSUs, for the government. For the government, generally under the Act, it's written that only certain types of functions, which include the sovereign functions of the government, are not included. Otherwise, every other act is included. Sovereign functions have also been defined under the various judgments of the courts, like primary, inalienable, and non-delegable functions. Otherwise, everything is included under the Act. Practically speaking, Section 3 and 4 are more relevant for MSMEs. As I said, mergers is not so much relevant for them. And if you look at the parameters, the linkages of the foundations of the Act as defined in the preamble, MSMEs have very strong linkages. For example, the first one is to prohibit all such practices which have an appreciable adverse effect on competition. This is a very widely used term, appreciable adverse effect on competition, AAEC. When the anti-competitive practices are prevented, then the smaller player of the market get a freer chance to fairly participate and ultimately sustain competition in the market. The second is to promote and sustain competition in the markets. With this objective, the competition is expected to exist between the large or gigantic industries, the smaller and the bigger one, and also the small ones. Everyone is given a fair chance, making markets work in the interest of consumers. C, to safeguard the interest of consumers, the more the number of market players and greater the level of competition, the higher is the choice of the same product available to the consumers, and the better products with higher technology, newer products. The effort is to lower the entry barriers and facilitate new entrants and new technologies. And finally, the D part is to fulfill the notion of freedom of trade among various market participants within the territory of India. Freedom to practice trade and profession is guaranteed under the Constitution of India under Article 19, and more the number of SMEs, higher the competition, as I said repeatedly. Above all, the process of unemployment will also be solved by large number of such enterprises and by self-employment initiatives, new startups, LLPs, and small private companies. We are very fortunate that India is considered the startup nation of the world and number 3 virtually now, after USA and China. And in terms of unicorns, we have already achieved more than a century now. We have achieved 101, maybe 102 is on the way. I recently read something more about one or two more, which are called unicorns, and so on. At times, cooperation agreements among the SMEs may be necessitated for the survival of the firm, because at times they have to get together under the platform of the trade association in order to discuss common problems and to undertake advocacy with the government or regulators. But then it has to be borne in mind that they have to stay within the boundaries on what is permitted, do's and don'ts, and they should not be discussing prices and supply and production and so on. Otherwise, they could go on the wrong side of law, which should be avoided. Section 4 of the Competition Act relates to the provision of the abuse of dominance or smothering the level of healthy competition in the market. And of course, at times, these are relevant provisions for the MSMEs when they have to be protected from the adverse effect of the functioning of the large MSME, sometimes the tech behemoths and so on and so forth. Some illustrative cases, very briefly, I won't take much of your time. In the case of Bengal Chemists and Druggists Association, CCI had imposed a penalty of 18.38 crores on this association BCDA for their anti-competitive conduct. This was a suo motu case taken up by the CCI, wherein this association had directed the retailers to sell the drugs only at the MRP determined by it, and this was considered to be anti-competitive. And in this particular case, not only the association, but 78 of its senior office bearers were also held personally liable. I'm mentioning, I've singled out this particular thing because At times, the MSMEs, they discuss things under the umbrella of trade associations, and they have to be careful on what is to be discussed and what is not to be discussed. I just mentioned about the CCI taking a very nuanced view. I'm not saying the word treating the kid glove. There was a case, cartelization in respect of tenders floated by Indian Railways for the supply of brushless DC fans, in which case, even though the evidence proved that there was a meeting of minds and they could be easily, they could be held guilty of collaboration and also collusion, but CCI passed a cease and desist order along with different monetary penalty for different parties because it was the days of the corona, and they felt that these MSMEs should be let off with just a warning and in one or two cases maybe a bit of fine. In auto parts case, this was a very important case where I would like our friends from PhD chamber, those who are dealing in the auto parts business, either selling or either manufacturing. This is a famous case of Shamsher Kataria versus Honda Steel Cars. In this case, CCI held 14 car companies liable for abusing their dominant position in the relevant market supply of spare parts and imposed a hefty fine of 2,544 crores. And this is a classic case or a landmark case because in this case, CCI delineated a separate market for the first time, which was not only the market of manufacturing or selling the cars, but also the after-sales service and the spare parts. And in this case, that was also included as a separate market, and therefore, this was something which should be known. And finally, before I go to my finishing stage, in the government procurement, when the MSMEs are submitting their tenders, government is a big buyer. They should be very careful that there should not be any meeting of minds or allegations of collusion. Even in common dealership supplies, channel partners, one has to be extremely careful. Two more things which are not so well known. One is the provision of compensation under section 53N of the competition law. Enterprises are eligible if they have suffered a harm because of anti-competitive conducts of enterprises by cartelization or abusive behavior. They can seek damages under section 53N through the judicial forum, which is earlier it was Competition Appellate Tribunal, now it is the NCLAT, and where they can go and the competition. But this is yet to receive a full steam because it's not so well known. But hopefully in the next couple of years, globally it is very well advanced and developed. In section 32, which is a provision which is again not so well known, actions taken outside the territories of India, CCI has got powers to look at them. And at times there are global cartels. And if our MSMEs have suffered on account of their global cartelization, they can file damages. Not exactly, I mean, I wouldn't like to say that they should do it in the courts of London and Brussels and so on. But if there are judgments available, they can also join them and file their compensation claims. So that's all that I wanted to say. And just one more thing, that in the new age technology, in the digital space, MSMEs are gradually going into this area also. It would be useful for them to look into the new developments in the digital space, in the competition law regime and allied regulations, and make sure that they stay on the right side of law. Also, they get the benefits of the legal protection. So, friends, my final word of advice would be that competition law is your friend, and it is there to help you, to protect you, to shield you and take care of your interest whenever it is required, and you should cooperate with them. Make sure that you know the provisions of the Act, and occasionally study the advocacy booklets given out by the Competition Commission of India. So with these words, thanks a lot for your attention, and I look forward to hearing Mrs. Sangeeta Verma. Thank you.